Hello, everybody, and welcome back to SEC Roundup. I'm Nick Morgan, the co-founder of ICAN, the Investor Choice Advocates Network, and the co-host of today's SEC Roundup. I'd like to welcome our guest co-host, ICAN Advisory Board member and CATO Director of Financial Studies, Jennifer Schulp. Jennifer, thank you for doing this.
Thanks for having me on today. Happy to step in.
And our special guest today is Brian Barnes, who is a partner at Cooper and Kirk. And for purposes of today's discussion, the most important thing is that he represented Alpine Securities Corp in its litigation with FINRA, a decision that came out recently that we're going to talk about. But Brian, thank you for coming on.
Thanks so much for having me.
Looking forward to your comments. Before we get to the decision that just came out, Jennifer, I don't know about you, but I hear at least as many complaints about FINRA as I do about the SEC, and maybe more. And certainly this decision in the Alpine v. FINRA case has been long awaited. Maybe you could give us some of the context leading up to the decision that came out last month.
Sure, happy to. And yeah, I certainly hear complaints about FINRA. I hear complaints about the SEC. I hear complaints about a lot of things. But FINRA is no stranger in that book. So let me just walk through a little bit about how we got to where we are. And then I think Brian can talk a lot more about the case itself. So this case arises from a FINRA expedited proceeding to expel Alpine Securities Corp from FINRA membership on the basis of Alpine's alleged violation of a pre-existing cease and desist order. It's kind of long-standing litigation between FINRA and Alpine. There's a lot of twists and turns, most of which are not terribly relevant for what we're going to talk about today. But needless to say, there's been a lot happening in these cases. The expedited proceeding that FINRA used is a specific proceeding that cuts short kind of longer FINRA disciplinary proceedings and allows any sanction, including if the firm is expelled from FINRA membership, to take immediate effect. And that sanction isn't stayed pending any further appeal of the decision to the SEC. And as listeners of this podcast already know, FINRA is a self-regulatory organization, which is a bit of neither fish nor fowl when it comes to exercising government authority. So in response to FINRA's expedited proceeding, Alpine sought a preliminary injunction in district court to block the proceeding, arguing that FINRA's authority to do so was defective. This is pretty broad arguments made, to kind of in the alternative. If FINRA is fish, a private entity, the federal government gave it too much authority in violation of the private non-delegation doctrine. And if FINRA is a government entity, the fowl, and I say fowl with a little bit of pun in there, FINRA's expediting proceedings violate the Constitution's appointments clause. Well, the district court denied the injunction, but on appeal to the DC Circuit, the case made huge waves when the DC Circuit granted an emergency motion for an injunction pending the appeal, which requires a finding that Alpine was likely to succeed on the merits of its challenge. And what got so much attention was an opinion by Judge Walker, who raised questions kind of broadly about FINRA's constitutional status and the future of SROs generally. Fast forward to last month, the entire DC Circuit has now weighed in, and the majority opinion found on comparatively narrow grounds that the district court should enter an injunction barring FINRA from giving any effect to an order expelling Alpine or imposing other sanctions until after the SEC has had the chance to review such an order. Notably, Judge Walker filed a separate opinion resting on broader reasoning that he would have enjoined FINRA's proceedings in their entirety. That looks a lot like the arguments he made on the emergency motion for an injunction pending appeal. Couple of interesting things to note about this case, and I suspect Brian might touch on these. It's arisen in the context of a preliminary injunction, which muddies the waters about how definitive these conclusions are. But that doesn't mean that the decision itself isn't consequential, because it is. And also of note, there are other challenges making similar arguments that have been working their way through the courts. And we've been seeing more challenges to FINRA's authority, kind of riding on a boost from recent Supreme Court cases that have related to the authorities of administrative agencies. So lots of exciting stuff to talk about here, and I can't wait to hear more from Brian.
I'm the same way. And just a couple of comments. I like your fish or fowl. I have heard FINRA similarly compared to like Schrodinger's cat, which is, sometimes it's private when it behooves it to be private. Sometimes it's governmental when it's helpful to be governmental. I think that's part of the frustration of people who are subjected to its regulatory oversight. I think one of the other frustrations is that, it's really got a monopoly on SRO status for brokers, and that can mean devastating consequences if you're subject to their procedures, and they don't have constitutional protection. So we were excited to see Judge Walker's initial opinion, and then eager to hear, Brian, why don't you tell us a little bit more about the decision that came out last month, where you think this case is going, and what's significant about it?
Sure. Yeah. And kudos to Jennifer for summarizing what is, in some respects, a fairly technical legal case in a way that I think is understandable for people. But Alpine is a small broker dealer. As Jennifer said, it got crossways with FINRA a long time ago and has been engaged in a lot of litigation over the years with FINRA. And it began making this argument rooted in the Constitution's separation of powers that FINRA is unconstitutionally structured. And one thing, just by way of background, that may be useful for people is we're kind of living through a period in the development of constitutional law up at the Supreme Court where this kind of newly more conservative court is taking separation of powers challenges more and more seriously. Plaintiffs who bring these kinds of claims get a lot more careful and serious hearing now, more sympathetic hearing up in the Supreme Court than they used to. And as a result, we've had this series of decisions from the Supreme Court saying things that really kind of lay the groundwork for a constitutional attack on FINRA. And the specific doctrine that we ended up, at least at the preliminary injunction stage of things, prevailing on in the DC Circuit was this private non-delegation doctrine. And basically what that doctrine says is the government can't give governmental power to private entities without exercising sufficient control and supervision over what those entities do. And what the majority did in our case in the DC Circuit is they said, well, FINRA, you have to be a member of FINRA to operate as a broker-dealer. It's illegal under federal law if you're not a member of FINRA and you try to function as a broker-dealer. And these guys at FINRA have the ability to kick Alpine out of their putatively private club, and as soon as they're kicked out, it becomes illegal for them to operate under federal law. And that expulsion decision is potentially would take effect immediately without any kind of review by anyone in the government at the Securities and Exchange Commission or any court or anything. It would just be, you flip a switch and the lights go out at Alpine. And what the DC Circuit said is applying this private non-delegation doctrine, that's not enough supervision. It's not good enough that, maybe in theory, after Alpine is closed, FINRA chops off Alpine's head and then the Securities and Exchange Commission can come along later and sew its head back on, after the guillotine blade falls. That's no remedy at all. That's not government supervision. And so the thrust of the majority opinion is, okay, at least for the time being, this enforcement proceeding against Alpine can go forward, but the sanction of being thrown out of the industry cannot take effect until the Securities and Exchange Commission has an opportunity to fully review whatever FINRA does if it ultimately decides to try to expel Alpine. So we regard this as an enormous victory for Alpine because we think it's a lot more likely to get a fair hearing from the SEC than it is FINRA. And so we think that it's a really big victory. But as Jennifer mentioned, there's also a concurring opinion. So this is a 3-judge panel that ruled in our favor. The 2 judges in the majority had the narrower ruling. And then there's this concurring opinion from Judge Walker. And what Judge Walker says is, I agree with everything the majority has said, but I think we should go further. This whole setup with a private entity that is purporting to exercise government power, that's, acting as a prosecutor and as a judge, and deciding under federal law whether you're allowed to function as a broker dealer. This whole thing is just root and branch unconstitutional, and we ought to say that. And notably, the majority does not really tangle with what Judge Walker said in his concurrence. They just say, well, we're going to leave that for another day. And so FINRA now has a giant target on its back, and people who are involved in these enforcement proceedings going forward, I think, as Jennifer mentioned, you're going to see a lot more of these kinds of arguments. And until this set of issues ultimately gets sort of fully fleshed out, potentially in the U.S. Supreme Court, there's just going to be a cloud of uncertainty over everything FINRA does.
Yeah, I agree. So what are the next steps, if you can say, in your case? Is the SEC the next stop? Are you back down to the lower court, or what?
Yeah, it's not clear, and I'm not in a position to say precisely what Alpine's plans are for the case going forward, but I'll just mention there are kind of three possible places for the case to go from here. It won't go to the Securities and Exchange Commission. Interestingly, we filed in federal district court. We went up on appeal to the DC Circuit. The next stop going up in the appellate court system, of course, is the U.S. Supreme Court. So it's possible really neither side got 100% of what they wanted out of at least the majority's opinion here. And so it's possible either side could seek U.S. Supreme Court review. It's also possible, as I mentioned, this was a 3-judge panel that heard our case in the first instance on appeal. And it's possible that either side could ask the full DC Circuit sitting, they call it en banc. They could ask the en banc DC Circuit, all 11 judges on that court, to rehear the appeal. So that's possible. And then the third possibility is we just all sort of go with what the panel did in our case. And that would mean we go back down to the district court and we'd have further proceedings, including proceedings basically about whether, what Judge Walker said in his concurring opinion is right. And we've got actually a host of other legal challenges, including a 7th Amendment civil jury trial argument and various other kinds of arguments we're making, attacking this regulatory regime. And so the district court would have another crack at the case if we went that way. So time will tell what happens.
Right. Well, needless to say, lots of us will be watching. So good luck in whatever path it takes. And I think both of you commented on the possibility that others will see Judge Walker's initial opinion or this later decision by the panel as a roadmap for other challenges. I think there was an oral argument yesterday in the Fourth Circuit in another slightly different context, but challenging sort of the root and branch of FINRA. And I've got to think there are going to be plenty more of those on the way. Well, maybe we'll leave it there. Brian, thanks so much for coming on. And Jennifer, thank you again for co-hosting. Everyone else, we'll see you on the next SEC Roundup. For more information about ICAN, go to icanlaw.org. Thank you. See you next time. Bye.